All right, guys. Well, thanks for joining me on a Wednesday night at 7 o'clock East Coast. We've got a West Coaster joining us. Um, and so this is going to be generally estate planning, but I'm going to do a little bit of focusing on estate planning for parents, especially with minor children. So I will go into a little bit of that. If you don't have minor children for that section, maybe you can think about, a friend or a sibling who might, be able to take advantage of this in the future. We're going to be recording this and sending it out after the meeting, so you can always share it with somebody. And that's a great way to, get the information out to people. So I'm Leslie Sultan. Thanks for joining. I'm an estate planning attorney. I'm a mom. I have two girls. Those are them in the picture. I've been in practice with my own law office since 2010, and we try to take a personal approach, especially with estate planning, on all our cases. So, a little disclaimer, this is attorney advertising and marketing. Anything discussed here is not considered legal advice, so don't take any action based on this information without actually consulting a legal attorney. Nothing in this workshop should be taken as engaging or offering an engaging in legal or unauthorized practice of law. This is not intended to create an attorney-client relationship. All right, so now that that fun stuff is over, why is estate planning with minor children so important? So, legally, if something happens to you and you don't have an estate plan in place, your children could be placed in foster care, and a stranger, via the judge, would decide your children's future without any input from you. So, estate planning is really important because it gives you, the parent, the ability to make your wishes known regarding your children, who would raise them, and if there's an inheritance, which hopefully there will be, how it would be distributed to them. So when we talk about people coming in and raising our children, we're going to call them guardians. And I break it down into long-term guardians and short-term guardians. So long-term are the legal, they're going to represent, raise your children. So this can be a very daunting decision. You've got to figure out who's going to raise your child, and that can be hard for some people to think about. But if you can't be there, who would you want to raise them as if they were their own? All right, so don't let choosing guardians of your children be the reason to not get a plan done. We always encourage people, just make a decision, put it in writing, at least on paper. Think about it. You can always change your mind. You might nominate your best friend, and then you guys have a falling out, or you realize, their spiritual beliefs aren't what you'd want to raise your children, and you can update your documents and change it. As long as you have a decision and a plan in place, it's better than no plan at all. So when picking long-term guardians, you want to choose one primary guardian, have at least two backup guardians. Okay, so if number one is not available or not willing, then you have backups. You can choose a couple, and then if you're going to choose a couple, you decide, are they going to work together? Do they have to be together to make decisions, or can one act alone? Are you going to choose friends or relatives? And then what are their parenting styles, their moral values, their health values? These are things that you want to be ideally aligned with how you raise your child, so there's a continuation of those values. You also want to pick someone that knows your child, because it would be very awkward, the greatest person in the world who doesn't know your child coming in and raising them. Also, where do they live? Are you willing to have your kids relocate? The guardian that I would choose is in Canada. So, luckily I take them to visit Canada, but this is something to think about. The age of the guardian, right? If you're going to name a parent or and they're elderly, you have to think about what could happen as they age, especially if the children are really young. And then, are they good with money? This is a big one, although it doesn't have to be a deciding factor, because as we'll talk about, you can have the guardian raise the children and have somebody else who is good with money be the trustee and manage the money for them and pay for their needs whenever the guardian's requesting it. And then, of course, you do want to check with these guardians to make sure they're okay with this potential decision. So I don't know if you downloaded my workbook. It was in all the emails, but if you did, now is where you would turn to the page and write down who you would want as your first number one primary guardian, and then who would be second and third. So I'll give you a minute to write that down. If you don't have the workbook, you can email me and I can send it to you. And you could just jot it down on a piece of paper for now. And at the end, I'm going to tell you what you can do with this workbook once it's all filled out. All right, so I don't know if you guys need more time, but I would say just jot down 3 people for now, and then we can revisit it later. Now, guardians for minor children, short term is, imagine you're on a date with your significant other and you're in a car accident and the two of you don't make it home and you're both the parents. Does the babysitter know who to call, right? And what we've seen is if she calls 911, the police are going to come, they're going to see that there's nobody to take care of the kids, and they're going to call Child Protective Services. Not because anything's been done wrong, but because they have to make sure that the children are in a secure place. So now the children wind up in foster care until somebody can come and get them, which is what no parent wants. So one thing you can do is name short-term guardians. There's actually a short-term guardian nomination form that's legal, and that can be given to the short-term guardians, to the schools, so that if a temporary situation comes up and the kids need to be picked up from school or be held overnight, for example, my aunt in Canada, it's going to take her a little while to fly down here to get to my kids. They can watch the kids for that temporary time. So again, you're going to want to pick 3 short-term guardians that can stay with your children until the long-term comes. You know, it would probably be more than 30, 60 minutes. I'm not sure why I have that there. Sorry. How well do they know the children, right? Is it a friend? Is it one of your kids' friends' parents? Do you feel safe with them in an emergency situation? Are they going to be relatives? You know, you can choose however you want. And obviously it's going to depend on, you know, what your what your dynamics are. I don't have much family here in New York, so I would have to choose friends or distant cousins. And then, of course, you're going to want to check with them, make sure they're okay with this role. So make sure that, you know, you're nominating a short-term someone who is local, right? Again, you don't want them having to hop on a plane and come out because that could take a day or 2. And again, the goal is we want to keep them out of foster care. We want to be able to have someone show up and, you know, take the kids to a safe place that you've appointed. The other thing when it comes to guardians is you can do a guardian exclusion. So this is where there's somebody that you absolutely under no circumstance want them to raise your children. So you can put that on a form. You can even say why. And this would be shown to a judge if there was ever a competition, so to speak, where conflicting petitions, where my aunt is coming and she's trying to petition the court to be guardian, and then a sibling who I haven't spoken to in years makes that petition. And I don't want that sibling to raise my children. The judge will obviously take that into account because I took the time to put that down in writing. Obviously, it meant something to me that that person be excluded. So if you have your workbook, here's where you would fill in primary, secondary, and third. All right, so I'm going to move on. So we're going to talk about trust a little bit. This is a big one. It's a complex topic, but I try to break it down really simple so that people can understand. And then we're going to look at who could be a trustee and an executor. So a trust is a legal document. It gets signed and notarized, and it's effective during your lifetime. It can work during a disability and, of course, after death. And because the trust is effective during your lifetime and you can change it, it's referred to as a living document. So it's essentially a contract that I make with myself for my estate for the benefit of my beneficiaries. If you've ever been involved in a contract, selling something, a house, it's a big stack of papers and it says what, you know, all of the terms. That's what a trust is. It's a contract. There's 2 types, revocable and irrevocable. For today, I'm mostly going to focus on the revocable because those are the ones that we recommend, you know, in the majority of situations when there's parents of minor children. So it's, again, an agreement between the grantor who creates the trust and the trustee, who's the person who agrees to hold the assets in the trust, and it provides instructions for the trustee for how to distribute the assets to the beneficiary. While you're alive, you are all of those 3. You're the grantor, you're putting the stuff into the trust. You're the trustee, you're writing the checks, you're refinancing the house, And then once you pass away, your successor trustees step up and follow the instructions for how to distribute the assets. Okay, now in irrevocable, we use these more when it comes to elder law, retirement, where people are looking long-term for not spending all of their life savings on long-term health care and being able to qualify for Medicaid. In New York, we have a really fantastic Medicaid program. So if you can move all of your assets into a trust that's controlled by somebody else during your lifetime, then you get asset protection, and that prevents Medicaid from taking those assets after you pass away. So similar to the revocable trust, everything gets put into the trust and someone else controls it during your lifetime. And then that trustee is tasked with managing those assets for my benefit as the original grantor, and then my children as the the beneficiaries later. So we often call this a Medicaid asset protection trust. An example I like to use here is a wagon, right? So this kind of gives you a visual of what a trust is. So the trust itself is the wagon, okay? So you create the wagon and then you put all of your assets into it. So one of the things that happens when we die, if we don't have a trust, is our family's going to wind up in the probate court. And I'll explain that in a little bit. So once the assets are put into the trust, the wagon as here controls all those little toys. You can see in the middle image, the assets are not in the wagon. The toys are outside. And she's sad because that means that the trust is not controlling anything. She's going to pull that wagon and all her toys are going to stay behind. So this is called funding the trust. So sorry, if anybody is unmuted, if you could please mute yourself, we'd appreciate it. So we call this funding the trust. All assets that are in the trust avoid probate court and are immediately available to be distributed according to your wishes. It's actually a will substitute. So a few things to highlight: a trust has lifetime benefit. It provides for distribution of your assets. You can list your beneficiaries on your life insurance as the trust. So for example, minors cannot inherit legally, right? So if you list a child as a beneficiary in your life insurance and you pass away while they're still under 18, that check cannot be written to them. In fact, a court process has to happen where a guardian is appointed, and then that person can receive the money for them, hold it till they're 18, then get permission from the court to release it, and then release it out when they're 18. Instead, you can make the trust the beneficiary, give instructions to the trust to hold it until they're a little bit older, because an 18-year-old who's got a dead parent probably shouldn't be receiving a huge chunk of money. And then it can be distributed later when they're a little bit more mature, graduated college, gotten married, had kids, whatever the situation is. And again, the beauty of a trust is because it's a contract and the contract is controlling your assets, it avoids the court probate process. Then it provides for successor trustees upon your death. And if you're still alive, but you have incapacity issues, dementia, Alzheimer's, it can go into effect then as well. And again, if you have a guardian for your children that might not be financially savvy, the trustee can manage the assets while the other person's raising the children. And then as they need it, the trustee writes the checks. The trust can manage your property. Even if you're incapacitated, it can address appointing disability guardians. So if you have an outright inheritance to somebody who's receiving government benefits, they can be cut off from those benefits because they just got that money. And technically they won't be back on those benefits until all the money is spent. And that's probably not what you wanted, that inheritance to go for. So you can set up sub-trusts or special needs trusts that holds the money for those people so they don't lose the benefits. It's really a great tool. It's good. There's tax planning. I won't get into that today. You can revoke or amend it during your lifetime. And the costs actually tend to be lower than what it would cost to do a will and then have your family pay an attorney and pay the court fees to probate that will. So what is a will? Most people know what a will is. It's a legal document in which you give certain instructions for how your assets are going to be transferred. Your will directs the distribution of your assets. And when you formally nominate guardians, that's also done in the will. So we always recommend, even if you're doing a trust, if you're a parent with minor children, you're going to do what we call a pour over will. That's going to have the guardians in it as well. And you would appoint an executor who's going to be in charge of that process and make sure that the distributions happen according to your wishes in the will. Same as with the trust. So we call the will has an executor and the trust has trustees. So the benefit of a will, of course, is it allows you to appoint guardians for your minor children, and you can even set up a trust through a will, although I don't recommend that, because then you're setting up a trust through the court system, which is more expensive and takes longer when you could have done it during your lifetime. So unfortunately, wills, I saw Janet Nation came on and she did a video the other day. She said, where there's a will, there's probate court. And that's 100% true. That was a great line. Anytime you have a will, it has to go through the courts to be validated. And in New York, in California, the probate process is slow, it's expensive. So you have to, depending on what state you're in, you really don't want to have to use your will for your distributions. And although a will might cost less now, as I said, it's going to cost more later on. So if you're deciding, do I do a will or do I do a trust? You have to decide how much, kind of what your assets are. What is it going to look like for your family to probate that? If you have, for example, rental income, like let's say I have a 2-family house and I live in one apartment and I have tenants in the other apartment and I pass away and I only have a will, there's nobody who's legally allowed to collect that rent from the tenants until that will is validated, probated, and an executor is appointed to now go and collect the rents from the tenants. It can be very problematic. And of course, that affects the value of the inheritance for my children. Also in New York, it can take a long time. I mean, the average is maybe 4 to 6 months at best. I have cases in Brooklyn, Kings County, for example, that are taking years. It's a nightmare. So, and the other thing, which I'm not going to get into, but probate is public. So once you file with the courts, it's public record. Nosy neighbor Nancy and all the creditors, evil predator Paul, will know exactly what is in your will because it's public. When I do presentations, I like to talk about celebrity estates. And I can tell all kinds of details because the minute their will goes through probate, the media gets a hold of it and it's just spread all across the news. It's very public. So again, when you're deciding between a will and a trust, just know that a will has to be probated. That's a requirement. You cannot take that will to the bank and say, give me my money. They're going to say, we don't know if this was done, in your kitchen with fake signatures. You have to go get it approved by a judge. A trust absolutely avoids probate as long as it's funded, right? So as long as you've put your toys into the wagon, you're pulling the wagon. The minute you pass away, the next person just grabs that handle and now they're pulling the wagon. No court involved. It saves your family lots of time and money because they don't even need an attorney at that point. They just start taking over. So a trust avoids probate and, oh, I have that twice. Okay. So the bottom line, every family is different. I don't necessarily recommend one over the other. It all depends on your family and, you have to determine what feels right for you under your family circumstances. And of course, I would recommend consult with an attorney, estate planning attorney, to make sure that you're doing what makes the most sense for you. But I do see generally in my practice that most people receive the greatest benefit overall from having a trust. A question is in the chat box about what about property that's like jewelry or sentimental stuff. Actually, that's a really great question, Jennifer. Thank you for asking. We're actually probating an estate where they put all the furniture, the lamp, the desk, the couch in the will for distribution. And what does that mean? That means every single person who's been identified to receive those items, and trust me, it was a lot, has to be notified and come to court and either sign a waiver or, acknowledge that they are taking their share. It's an unfortunate burden for the whole family. A trust, on the other hand, would have been the better way to do it because, again, it's a legal contract. You can specify, I want my stamp collection to go to my brother. I want my paintings to go to my friends. And it will be distributed without court involvement. Nobody needs to sign anything necessarily. So they say if you absolutely want it to be enforced, you should put it into the trust or your will. But we don't recommend, if there's a lot of distributions, to go through the will, because it can get very burdensome for the family, and nothing can get done until everything has been distributed and completed. Okay, so I see some more questions. I will get to those in a minute. The last one is a trust possible when I'm self-employed? Yes, it's not about, your employment. It's about what you own and how you want it to pass. And we can go into that a little bit more later. So again, we're going to think about, this is a workshop. We're going to pick some trustees and executors right now. So consider these facts. You want to pick at least one primary that's going to be the trustee and or the executor, and then you're going to pick a backup. You can pick two people, but just keep in mind, if you have co-trustees or co-executors, they both have to sign the checks. They both have to sign the court petitions. They both have to agree, or nothing's going to get distributed or handled. So I caution people, if they're thinking of doing two people, that might not necessarily be the best situation. They should absolutely be someone you know and trust, and whose judgment you trust. So for example, as I talked earlier, you might have your children being raised by a guardian that's not so financially savvy, but now we're talking about who's the financially savvy person that you're picking. That person might invest the money and have it grow for a few years. You don't want a risk taker. You want someone who's really thinks these things through. So consider their personalities, their experience in business, their availability, right? Because if the guardian needs them, they're traveling overseas somewhere, that's hard to deal with. They're not going to get a check for a while. So these are hard decisions, I know, but obviously it can be. You at least want to pick someone now. You want to at least have something there, and you can always change it. But don't let this hold you back from doing your estate plan. It can be a relative, trusted friend, adult children. You can even have a corporate trustee. There are commissions that a trustee can take, statutory by law. But what we find is that the corporate professional trustees obviously add a little bit onto that. So that's going to be the most expensive route. But for some people, that's the only route. And that's what you have to do. And then, of course, speak to these people and ask them, are they comfortable in this position before you actually execute everything. So every trust needs a name. So for example, mine is the Leslie Sultan Loving Trust. People could do the Sultan Family Trust. You can name it whatever you want. Some people don't want their name on it because they think if it's not their name, a creditor couldn't find it. Some people don't care about that. So if you're filling out the workbook, you're going to write down a trust name and then the trust type, because if you're going to send this to me, so we're drafting, we need to know, are you choosing revocable or irrevocable? So again, if you're parent, minor children, you want to control, you want to hold the handle on that wagon, you're going to do a revocable trust. If you're really kind of setting this up for mom and dad who are elderly and they want to do Medicaid planning, you're going to do an irrevocable trust. Okay, so here in the workshop is where you would add, on the workbook is where you would add your primary trustee, the first one, 2 backups. And then, as I said, we're always going to do a will that's a pour over will, because just in case some toy didn't make it into that wagon, that item will have to go through the probate process. And so you're going to need an executor for the wills. They can be the same people. Okay. The only thing I would caution is do not name what we call a foreign, and someone who lives out of the country as your trustees, because once someone out of the country is the trustee, it creates a foreign trust, and foreign trusts are taxed much higher. So we want to avoid having anyone who lives out of the country be the trustee. Okay, so I'll just give another minute for you guys to fill that part out. And then I'm going to move on to power of attorney. Okay, so what is a power of attorney? So power of attorney is a legal document that gives your agent the authority to pay bills, make financial decisions, manage investments, file tax returns, mortgage, everything. um, Everything legal and financial, the agent of your power of attorney can do while you're incapacitated. This is really important. My mom has dementia. She lost the ability to write checks and manage her own finances. She did a power of attorney. And so my uncle, who's the primary agent who lives in California with her, he's taken over. And then when he passes, I'm named as the successor and I will be able to take over. And it's a smooth process. When a power of attorney does not exist, and this is really important, and most people don't realize this, and there's an incapacity issue, a guardianship proceeding has to happen. And these are crazy. Okay, so this is where the court, a judge, all these attorneys have to get involved to determine, does the person have capacity? Are we going to take away their ability to make decisions and give that power to somebody else? They could appoint somebody that person doesn't know if there's nobody around to apply, or even a loved one will have to apply for their family to take care of them and hire an attorney and go through this process. And it's, that's a guardianship is something I would never want someone to have to go through. And it's really simple. If you sign a power of attorney, the right power of attorney, there will not need to be a guardianship proceeding. So again, in a guardianship proceeding, that's the person's appointed by a judge. They may or may not even know the person who they're the guardian of. It's costly, it's time consuming, and ultimately the person no longer has control and the guardian is now making decisions. If you've ever heard of guardianship before, you've probably heard a bad story about how the guardian mishandled the money or didn't pay a bill. We've seen where life insurance payments weren't made, and so then the person lost all of their life insurance, or they didn't pay a timeshare, the annual fees, and they lost the timeshare. So yeah, these are not good. It's not a good thing. Power of attorney is really important, really powerful tool. So if you're going to do a power of attorney, and this should be done for anyone over 18, you're going to pick one primary, one backup. If you're married, that could be your spouse. It could, obviously wants to be someone you know and trust. Hopefully they have good financial and business decisions and that they're available. And of course, it could be a relative, friend, adult child. And then you want to ask them, make sure they're okay with this position. There are things called durable power of attorneys, which is the one that we use in New York. There's springing, but I don't like springing because it requires 2 doctors to sign off. And that means you have to take, mom or dad to these 2 doctors. And if there's a capacity issue and disability, sometimes it's really hard to move people around. So we like the durable power of attorney better. Okay, so if you're at this point in the workbook or writing it down, here's where you're going to pick at least one primary and one backup. Okay, so similar to the power of attorney is a healthcare directive. So this is who are you going to appoint to make healthcare decisions for you if in the event that you're not able to. So same with my mom. My mom has dementia. She wound up getting COVID. She wound up in the hospital. She was totally disoriented, wound up in rehab center, and we couldn't get her released from the rehab center unless we had the healthcare directive. So again, luckily she had done these things. We were immediately able to speak to the nurses, figure out the treatment plan, and get her moved out as quickly as possible. So with a healthcare directive and a HIPAA, you're authorizing people to have access to medical information that otherwise is confidential, and then they can make informed decisions as the healthcare agent. So we strongly recommend when you do a power of attorney, you also do a healthcare directive. So again, you want to pick one primary, one backup. It can be a spouse, it can be a friend, kind of the same thing I've already talked about. If you remember the Terri Schiavo story back in the days, she was very young. I think she was in her 20s. She was married. but she had an eating disorder, severe eating disorder, and wound up having a cardiac arrest and living, but being completely incapacitated. And her husband didn't have a healthcare directive, so he did not have the authority to make healthcare decisions. He said his wife would not want to be kept alive under those circumstances, and he did the guardianship proceeding. He was appointed the guardian, and right as he's about to pull the plug for her, her parents stepped in and said, no, we are very religious, under no circumstances would we want her to die this young, God's gonna save her, whatever their theory, their arguments were. And this went back to court for 7 years, and this woman was alive for 7 years until appeal. The husband finally won. He was able to pull the plug and put his wife to rest. And so this could have all been avoided had she done a healthcare proxy. So you're going to want to list your primary and your backup, and also for HIPAA. And HIPAA, you can list several people. It doesn't just have to be, your decision makers, but you can authorize more than one person for the HIPAA information. All right. So the other question is what we call a living will. And a living will says, how do I want my end of life to be? So if I'm in a permanent vegetative state, right, just like the Terri Schiavo circumstance, do I want to be cremated? Oh, this is I guess I'm on a different one. Okay, yeah. So here, do I want to be kept alive on artificial ventilators, on artificial nutrients, or do I want them to pull the plug? So you can make this choice. And the best part about you making this choice and putting it in writing is that you can tell your family and they'll know what your wishes are. Because if you don't do that and they don't know, they could fight about it. They could have a hard time making that decision for you, right? This is a very common hospital scenario where the family doesn't know what to do. And, mom or dad is just laying there for a while until they can figure it out. So, the best thing you could do is let your wishes be known, put it in writing, give that document to somebody. And same with, burial, cremation, or are you okay with letting someone else decide? And then do you, are you okay with that? Do you want your organs to go to science? So what are your wishes? Let it be known. When I was 15, my dad died, and 6 months before he died, he'd had a minor heart attack. And, a little while after he recovered, he had a conversation with me and he said, I want to be cremated if I die. And I was 15. I didn't even know what cremation was. So he explained it to me and I understood it. And 6 months later, he died. And then my mom said, okay, I'm going to bury your father. And I said, wait, yeah, he wants to be cremated. And she's like, how do you know that? And I said, because he told me. So, this is a conversation between my dad at 55 and me, a 15-year-old. But it worked. I was able to honor his wishes. So, I hope that story can help some of you in thinking about how to, have these conversations. Someone's asking about a DNR, do not resuscitate. Yes, that goes in the living will. So some people who do not, you can either leave that language out or you cannot sign the living will. If you do not want to be resuscitated, or if you do want to be resuscitated, you would not want to have the living will on file, because the living will generally says do not resuscitate, or keep me on life support, or leave it up to my loved one. And so then you wouldn't necessarily want to sign one of those documents. So when we prepare documents for people, if they want that decision left up to someone else, then they would just not sign the living will. Okay, so I've powered through the main documents. Now I'm going to get to, assuming we've decided we're going to do a will or we're going to do a trust, how are we going to distribute our assets? So the first thing you want to do is talk about specific gifts, okay? Because specific gifts, as we talked about, furniture, etc., you want to distribute those. If you don't make the distribution, you never know where it's going to wind up. But also what we see is people want to give money gifts. So I want to give $5,000 to my best friend. I want to give $50,000 to my sibling. Okay. those money specific gifts come right off the top. So you have to be careful with those, right? So if the inheritance, after life insurance, so, I have a house, whatever, if the total is 500,000 and I say I want 100,000 to go out to these 5 people, I've just taken a huge chunk of my estate and distributed it. So now there's only 400,000 left for my kids. So you have to think this out, because the whatever you give off the top decreases what's left for the what we call the residuary, the residue, the rest of the estate. So, and the other thing that to think about is I could give $5,000 to my best friend, in 2023, but what does that look like 30 years from now? What is $5,000? With inflation, that could be like $500 then. So another way to do it is percentages. So instead of giving her 5,000, I might give her 10% or something like that. Okay, so you want to think about it in terms of long term. What could that dollar amount be? And how can we gift it in a way that actually honors what we're intending to do? So, and then you're going to think about your beneficiaries, right? So obviously I want my money to go to my children, but what in the unlikely event that my children aren't alive, where do I want that money to go? So you really have to, this is the really hard part about estate planning, is these tough questions, right? So if my children aren't alive, who does it go to? And so you have to really think about this, and you want to kind of even take it to the next level. So if my daughters aren't alive, I'd want it to go to my nieces and nephews. If they're not alive, who does it go to? Because if you don't name anybody, I could tell you as an attorney, probate attorney, it gets very, very complicated. We have to hire a genealogist. The genealogist has to find all the relatives, has to contact everybody. In fact, even with a will, we have to sometimes use a genealogist. And I don't want to get into that, but it can get very costly. So another negative point for wills. So again, when you're thinking about your distributions, you're going to do primary. How do you want it distributed? And then if they're not around, where do you want it to go? Okay, and the other thing, I don't think I have it on here, but one things that we talk about, especially with minor children, and I mentioned this earlier, is doing distributions. So I like to tell the story of Whitney Houston. Okay, so I tell this story a lot. So Whitney Houston, as you know, was married to Bobby Brown. They had Bobby Christina, and then they got divorced. Whitney Houston, as you know, died. And she did a will. And in her will, she left everything to Bobby Christina in trust. So it was held for Bobby Christina, and it said, I want a portion to go out at 18, when she's 18, another portion to go out when she's 25, and the final portion to go out when she's 30. And if she's not alive, I want it to go to my sisters. So when she died, I believe Bobby Christina was 16. She inherited a huge chunk of money at 18. Okay. And then if you know the story, Bobby Christina unfortunately died the same fateful death as her mother. And Bobby Christina did not do an estate plan. So who do you think inherited all of that money? Bobby Brown, who I'm sure Whitney Houston did not want, and I'm sure he didn't need that money. Luckily, there was the distributions, right? So the 2/3 of the estate, because she wasn't 25 yet, was still held in the trust. So luckily, most of that estate was able to be honored by Whitney Houston's wishes and go to her sisters. So that's one of the things that we recommend with estate planning with minor children is do distributions so that it's paid out in portions. Maybe a little portion while they're young, they get to kind of play with it, make those mistakes, and then as they get older, they can be more responsible with the money. So I don't know if if you have the binder, the workbook, that's where you can put some of your questions, just so you can understand what the estate planning process looks when we do it. We have a family planning session. So we kind of just like this workshop, we explain everything. We find out what your family needs are. We do this through Zoom. We have you complete an asset spreadsheet that gives us all of your assets so we know what you have and how to protect it. How do you have your bank accounts held? Are they joint with your spouse? Do you have beneficiaries listed? We have to go through all of that with you. Okay, and then from there we do the intake. You know, figure out what your plan, what you want. Do you want to do a trust? Do you want to do a will? We do everything at a flat fee basis, so it's, you know, right up front what you're getting into. No billable hours. I've been a client where I had to pay an attorney billable hours before, and it's not fun. So I appreciate being able to do flat fees for clients, and I know my clients appreciate it too. So once we get all of the information, we start the drafting. A lot of people say, how long does it take to get a trust? So it generally about 1 month to 6 weeks. You sign a legal agreement, you pay. We do a half payment and then the other half at signing, so you can break it up into payments. We send drafts to you to review, and once you review everything and approve it, then we schedule the signing ceremony. At the signing ceremony, we meet in person, we go through the binder, you sign all your documents. At that signing date, all of those documents are now in existence. They are in effect. Once they're signed, they can control. If you left my office and died, that trust or will would control. The power of attorney, I guess it wouldn't matter when you're dead, but would go into effect. So, you know, that's the, like, where people really feel that peace of mind because they've done it. And then we recommend that you revisit your estate plan every 3 years because things change. Maybe there's a new child born, maybe there's a divorce. You know, you want to make sure that it's up to date with what your needs are and what you're planning for your family. So yeah, that's basically my workshop today. So if you have taken the time to, you know, go through this with me, this is basically similar to what I would have done in the intake process with you. If you fill out that workbook after attending this workshop, I will give you a discount on an estate plan because essentially, you know, to be honest, you've spared me the time of having to go individually with each of you on doing the estate that intake. So we've done it sort of now. You fill out that workbook, send it to me. Once we do, if you do a trust, we will give you $1,000 off your trust plan. So I don't normally offer this. This is a special promotion for the end of the year to help parents or people do their estate plan. So I hope some of you will take advantage of this. Okay, so I'm looking at the chat. One of the questions that Jennifer's asking is who gets copies? So it depends what documents. So the trust, we only give to the trustee, the grantor, unless we're doing an irrevocable trust where there's a third party who's the trustee, then they would get it, potentially. It's a conversation we have. The power of attorney, I recommend that the principal, the person creating the power of attorney, holds that, because if it's ever in the wrong hands, that could be misused. But we do send copies of the healthcare proxies to people and all of the guardian nominations to the fiduciaries. So whoever's been nominated, we recommend sending them a copy so they know they have the document if they need it, and they can, you know, immediately show up and say, look, I'm the nominated guardian. Here's my paperwork. Give me the kids. Or I'm the healthcare person. Here's my HIPAA. Tell me what's going on. Okay, so yes, anybody who's attended today will get a copy of this recording with the workbook. Again, we can, so that you'll have the full recording. And if you want to listen to it over again, that's great. I say this same speech over and over again, so obviously some people could listen to it over and over again. And if you have any friends or loved ones that weren't able to attend, but you think they could benefit from this offer, then we will be sending the recording. You can share it with them along with the workbook. They can do the workshop and then send us the workbook, and then we can get started. So my contact information's here. This is where Leslie at Sultan Attorney, that's where you would email the workbook. This is my phone number. You can text or call. We're on social media. You can follow us. And obviously that's the QR code if you wanted to go directly to our website and schedule a meeting. So if there's any other questions, let me know. I've stopped the sharing. I'm going to stop the recording for the last 15 minutes and stay on for another, 13 minutes to answer questions with the recording off. So thank you all for attending. I hope this was helpful. And yeah, I look forward to working with you guys.